Okay, let the record reflect that the defendant is present, along with counsel for the defendant, assistant state attorney. Both sides ready to proceed?
Yes, sir.
Okay, before we bring the jury back in, there is one issue. I think the state had some exhibits it needed to introduce. And then there was a request that was pending that you were going to make a request for the court to take judicial notice.
As of yesterday, that was correct, Judge. As of this morning, the defense and the state have come to a stipulation in regards to that issue, if I may approach.
You may. Okay, Mr. Baez, is this true and correct?
Yes, sir, it is.
And Ms. Anthony, does this bear your signature, and do you concur with this stipulation that reads as follows? On July 2nd, 2008, Caylee Anthony obtained a tattoo with the inscription, Bella Vita. This Italian phrase translates to beautiful life. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Yes, sir.
Okay, thank you very much.
The other trafficking matter is the state would move into evidence State's Exhibits I, which are here on the table. These were both samples of the spare tire cover taken into evidence and testified to by Michael Vincent.
Any additional objections from the defense?
Provided these are just being entered into evidence, this is not going to be going into the sniff test area.
These are just going into evidence. Any further use we might put them to, we would obviously proffer to the court for full argument before we would go into that. We're not doing that at this time.
Right. And if that's the full understanding of the court as well, then I don't believe we have any objections.
Okay. All right, then we can bring in the jury. You can introduce those final two items.
One last thing.
Turn your microphone on.
One last
Okay.
thing. There was inquiry from the jury about wanting to view whatever that item was. I can't remember, number 313, was it?
They viewed it yesterday.
Pardon?
They viewed 313 yesterday.
Yeah. And our concern was how the jury reached that consensus to make that inquiry unless they were discussing the case and they're not supposed to be. And I'd like you just make inquiry, whatever you think is appropriate on that so we can move ahead.
I don't believe it's inappropriate for jurors to request to view an item, or as they have in the past, to notify the court that they can't see their monitors or any other matter. And I don't believe there's an whatever instruction counsel's suggesting, I'd be happy to look at. I'm hard pressed to imagine an instruction that would be appropriate.
Mr. Mason?
There being no requested instruction, Judge, then I would submit there's nothing for you to instruct them in.
Anything else from the defense?
No.
Okay. Then let's return the jury. Good morning, ladies and gentlemen of the jury. Did you heed my previous admonitions? Yes. Including but not limited, not discussing the case among yourselves or the other things I've admonished you about. Okay. State recognized presence of the jury.
Yes, sir.
And the defense.
Yes, sir, we do.
All right. State may continue.
Thank you, Your Honor. At this time, the state and the defense have entered into a stipulation, and we would ask that the court read that stipulation.
Okay. Any objections from the defense?
No, sir.
Stipulation between the state of Florida and the defendant reads as follows. On July 2nd, 2008, Caylee Anthony obtained a tattoo with the inscription Bella Vita. This Italian phrase translates to beautiful life. The parties have agreed to this fact, and it should be considered as true in your deliberations, bearing the signature of Mr. Frank George, Assistant State Attorney, Mr. Jose Baez, Attorney for the defendant, and Ms. Caylee Marie Anthony.
Your Honor, as a final housekeeping matter, the state of Florida would move into evidence states exhibits IP and IQ, which were previously identified by witness Michael Vincent as samples of the spare tire cover that were placed in metal cans.
What says the defense?
Subject to our previously mentioned limitations, yes.
All right, it will be received in evidence as states numbered.
IP will become state's exhibit number 322. IQ will become state's exhibit number 323.
State may call their next witness.
Your Honor, at this point, the state of Florida would rest.
Ladies and gentlemen of the jury, the state has now rested its case. May the attorneys approach the sidebar for a minute along with the court reporter. Okay, ladies and gentlemen of the jury, there are going to be some legal matters we're going to need to take up outside of your presence. That will be fairly lengthy. So we're going to recess and let you return back to your accommodations. We will reconvene tomorrow morning at 9 a.m. To continue the proceedings. Please remember all of my previous admonitions. Do not discuss this case among yourselves, nor with anyone else. Do not read, watch, or listen to any news accounts of this particular case. Do not conduct any internet searches on this case. Do not engage in any social media, such as Twitter, Facebook, or any other forms of media engaging in internet email contact with individuals about this case. Any additional instructions on behalf of the state
Nothing can be stated.
or the defense?
Nothing from the defense, sir.
Okay, members of the jury, you may be excused for the balance of the day. Okay, Mr. Baez, Mr. Mason, do you have a motion you would like to make? But prior to doing that, you handed the court some documents, a number of cases, and you also had a memorandum. I have not had a chance to read your memorandum other than a quick scan. The cases that you have cited, I am familiar with all of them except Barr, Kennedy, and if you would like, I would read those or you can go straight into your argument without me reading those. What is your pleasure? The reason I suggest that is because the state did provide theirs. I believe it was on Monday at the conclusion of business. And I did read the entire book that they presented, even though there were some cases I was familiar with. I did have an opportunity to review their cases. So what is the defense's pleasure? I have not seen those.
Make the argument, finish with this, and let you take under whatever advice you think necessary to meet cases formally.
Okay. All right, you may proceed.
It is well established in the jurisprudence of this country and in this state that at the close of the evidence by the state and/or again at the end of all of the evidence that is presented, we are entitled to present an argument to the court seeking a judgment of acquittal. In Florida, is codified in the Rules of Criminal Procedure 3.380. And the burden, as you well know, and I won't belabor that, is if the evidence is insufficient to warrant a conviction, then the court is supposed to step in and shall enter a judgment of acquittal. We know, and as I put in the memorandum, that if you view the evidence in the light most favorable to the prosecution, and there are elements that are not proven or not been established beyond a reasonable doubt, then it is the court's obligation to enter a judgment of acquittal as to the various charges affected. And for that principle, the Florida Supreme Court, in the case of Reynolds, R-E-Y-N-O-L-D-S versus State, found at 934 Southern 2nd, 1128 in 2006, enunciated that rule. No surprise, not academically new to any and all of us. Most recently, the Florida Supreme Court, a couple of months ago, while affirming conviction and death sentence in the case of Serrano versus State, S-E-R-R-A-N-O, the only cite so far is 2011 WL904071. The Supreme Court in this case, which I know the judge knows that I'm intimately involved in this type of case, capital cases, murder cases, the Supreme Court reaffirmed that there is a special standard of review that is required. The court said, at page 150, citing another case, a Darling case, a motion for judgment of acquittal should be granted in a case based solely or wholly upon circumstantial evidence if the state fails to present evidence from which the jury could exclude every reasonable hypothesis except that of guilt. Where the only proof of guilt is circumstantial, no matter how strongly the evidence may suggest guilt, a conviction cannot be sustained unless the evidence is inconsistent with any reasonable hypothesis of innocence. The question of whether evidence fails to exclude all reasonable hypothesis of innocence is for the jury to determine where there is substantial competent evidence to support that, and the court will not reverse it. The Supreme Court has further stated in Cox v. State, 55 Southern 2nd 352 in 1989, that one accused of a crime is presumed innocent until proven guilty beyond and to the exclusion of every reasonable doubt. It is the responsibility of the state to carry this burden. And when the state relies upon purely circumstantial evidence to convict an accused, we, the court, have always required that such evidence must not only be consistent with the defendant's guilt, but must also be inconsistent with any reasonable hypothesis of innocence. Our current rules and the circumstantial evidence instruction promulgated by the Supreme Court says as follows. Circumstantial evidence is legal evidence, and a crime may be proven by such evidence. A well-connected chain of circumstances is as conclusive in proving a crime as is positive or direct evidence. Its value is dependent upon its conclusive nature and tendency. Circumstantial evidence is governed by the following rules. 1, the circumstances themselves must be proven beyond a reasonable doubt. I'll digress momentarily and direct the court's memory to Dr. Garavaglia saying that she concluded that she would label this case as a homicide by indeterminate means, choosing the word homicide because in her view the circumstances established that by preponderance of the evidence. That is directly contrary to the law. 2, the circumstances must be consistent with guilt and inconsistent with innocence. And 3, the circumstances must be of such a conclusive nature and tendency that you are convinced beyond a reasonable doubt of the defendant's guilt. If the circumstances are susceptible of 2 reasonable constructions, one indicating guilt, the other innocence, you must accept the construction indicating innocence. And that is the jury instruction, which, if this case proceeds on to that level, then you will be reading that to the jury, and that is the law in the state of Florida now applying as to whether a judgment of acquittal should be considered. The state, in presenting its evidence, I will suggest to you, has established in the light most favorable to them that Ms. Anthony has a history of untruthfulness among family members and friends. And apparently the untruthfulness and representations for whatever necessary reasons to her regarding the existence of a nanny began in 2006. They have established by stipulation that the child is dead. There is no evidence to establish when the child died, other than in a monthly window of possibility, where she died, how she died, who, if anyone, was with her in attendance when she died, and they have failed wholly to rebut the reasonable hypothesis of innocence, that is, that there was accidental death and inappropriate efforts by those unidentified as of yet to cover up that accidental death. With respect to count 1, the first-degree premeditated murder, the evidence fails to exclude a reasonable hypothesis of innocence, and that is that there was no premeditation, even if there's a determination that there was a murder at all. When the element of premeditation is sought to be established by circumstantial evidence, the evidence relied upon by the state must be inconsistent with every other reasonable hypothesis. And I cite in the memorandum to the court the case of Smith versus State, 568, Southern 2nd, 965, First District Court of Appeal case in 1990. I'm going to talk about some of these cases after I get through the preliminaries. There has been, in this case, no evidence of premeditation presented to this jury or this court. There is a stacking of inferences, a stacking of speculation, but no evidence. The Smith case, Your Honor, is of particular interest, I suggest, also in this case, because of the nature of the facts involved. In Smith, the Tampa Bay police found the body of Judy Smith floating in the bay, the body having been wrapped in chains and a blue bedspread taped around it. Despite the fact that the lady was missing for some period of time, the husband defendant did not call the police and report it.
That's not Donald Smith, is it?
I'm sorry?
You said the Smith case, that's not Donald Smith versus State.
Donald Lewis Smith versus State.
First District Court of Appeals, 56872nd 965.
Yes.
Okay.
Yeah, you have it in the
Yes.
fact I gave you there. The court ruled in this case that even though premeditation can be proven by circumstantial evidence, where the element of premeditation is sought to be established by circumstantial evidence, the evidence relied upon by the state must be inconsistent with every other reasonable inference. And the court ruled in that case that, in fact, the conviction for first-degree murder had to be reversed, directing the court to reduce to second-degree murder because the state was unable to prove beyond a reasonable doubt the manner in which the homicide was committed if there was a homicide. In that particular case, there's no question of the fact that this woman died in that capacity, wrapped up in chains in a blanket and tape and in the water, drowned. There was no mistake. And that is a major similarity to the case that we have in a light most favorable to the state, except here, we don't have any cause of death. We have clear admissions from the experts that do not know the cause of death. And by the preponderance of the evidence, we have the speculation of Dr. Garavaglia that it was a homicide because she claims that 100% of people report things, some such thing. I'll ask you to read that case further. It is interesting also that, I just digress again a little bit, in the Serrano case, the prosecution has submitted that case also, where a circumstantial evidence case tried and resulted in a conviction. What a world of different set of facts. Nelson Serrano was convicted of the execution-style shooting murder of 4 people. 3 prior business associates engaged in litigation and fighting over millions of dollars, in which he had been expelled from the office and a history of fight. One, that victim number 4, purely the epitome of wrong place, wrong time. The young woman came to pick up her husband. And of course, the case got the notoriety in the appeal because she was a prosecuting attorney. But the fact of the matter is, there was no question as to the cause and manner of death of the, I won't say their name because of the publicity, but the victims shot execution style on their knees. Blood spatter, ballistics, unequivocal statement of facts as to the death. The issue of circumstances, whether or not Mr. Nelson Serrano was the shooter, and it went on for weeks and weeks and weeks and weeks and years, and to this point in the appellate courts, in the Supreme Court, that is, of Florida, regarding issues of alibi and so forth. But of course, as I said, the Serrano case reiterated the special test and a requirement in these type of cases that every reasonable hypothesis be excluded, or they cannot be a conviction. Another issue for the court to consider regarding count 1, the first-degree murder, is whether or not, despite the indictment charging premeditated murder, that can be satisfied by proof of felony murder. Ms. Burdick handed me this morning the case of Brooks versus State, which we already had and rely on also. Florida Supreme Court 2005, BROOKS versus State 918, Southern 2nd 181. The merger doctrine. That is the law in this state as of this date. Indeed, the underlying alleged felony of aggravated child abuse is merged into count 1 as a matter of law, because if there is an act, there's a single act. You may recall, and perhaps it did not ring loudly enough for the uninitiated, but the fact of the matter is, with every evidence that we could cross-examine and touch, no evidence of any prior trauma, injury, or act of violence whatsoever for this child. No heel fractures of any description, closed, open, or otherwise. No bone torquing, and so on. And the first 18 witnesses called, while they besmirched the character of the defendant with history of misrepresentations and lies, all confirmed that she, Caylee Marie Anthony, was in fact a dedicated, doting, loving, caring mother, always saw them happy, always saw the great interaction between the two of them. And I'll talk about why the aggravated child abuse count fails in a minute. But clearly, the evidence before this court mandates accepting the merger doctrine of Brooks.
One question, Mr. Mason, about
Yes, sir.
that. Are you familiar with the First District Court of Appeals decision in Lewis versus State, found at 34 Southern 3rd Edition,
I am
183, 210?
seeking to distinguish the merger doctrine of Brooks.
Yeah.
Yes, sir. Read
Which
it.
is
You got it.
pending, where they claim that the Supreme Court's decision in Brooks was dicta, and they talk about the legislative intent, and it's been certified to the Florida Supreme Court. How would you square Lewis'
I squared
interpretation of Brooks?
the same way you have for the last 6 weeks. The Florida Supreme Court says, and until they change, they're the boss on that issue, aren't they? And they say what they say, and Lewis is trying to undo it. Okay, nothing new about that. We've been seeing that for decades and decades. But the law today is Brooks. Let me move ahead on the aggravated child abuse at count 2. And I have cited and provided to you the case of Kennedy versus State, found at 59 Southern 3rd, 376. 4th District Court of Appeal decision 2011. Actually, dated last month, May 4, 2011. The Kennedy court said, and it's important to your consideration in this case as well, talking about the standard for aggravated child abuse. And it basically defines what it is. And it talks about the court making an error and not properly identifying what is meant by aggravated child abuse and reversing that case. Let me say this to you and read from the opinion. The complete definition that's required with the statute of maliciousness is where it comes down to. It may be established by circumstances from which one could conclude that a reasonable parent would not have engaged in the damaging acts toward the child for any valid reason, and that the primary purpose of the acts was to cause the victim unjustifiable pain or injury. And there is absolutely no evidence whatsoever for this court that if there was an act which the state alleges variously as I think I interpret perhaps chloroform and or duct tape, that evidence substantially subject to question and different interpretations, but nevertheless, all of the witnesses that knew and testified were asked about any history of torture, inappropriate discipline, any actions like that at all by the defendant against her little girl. In the absence of evidence proven beyond a reasonable doubt that the primary purpose of an act was not to cover up or not to conceal, but was to cause unjustifiable pain or injury, failing that, the charge of aggravated child abuse must be adjudicated not guilty in this case. As to count 3, aggravated manslaughter of a child, the state is required to prove beyond and to the exclusion of every reasonable doubt 3 elements. Caylee Marie Anthony is dead, proven. The death of Caylee Marie Anthony was caused by the intentional act or culpable negligence of Casey Anthony, not proven, and that Caylee Marie was under 18. It's the age that shifts it to aggravated manslaughter rather than ordinary. It is our position, our argument to this court, that what has been presented to you and this jury is the mere presence of duct tape on or near the remains, which is not dispositive of any intentional act and furnishes nothing stronger than a suspicion. And I cite, of course, reference the case of Ballard, B-A-L-L-A-R-D versus State 923, Southern 2nd, at page 482. There has been no evidence presented as to culpable negligence on the part of the defendant, which is defined as a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. That's standard jury instruction 7.7 and Florida statute 782.07. There has been no evidence whatsoever that could be considered at that standard of culpable negligence. And of course, there is no evidence whatsoever, none, as the causation of this child's death. Lawyering as to counts 4, 5, 6, and 7. I'm not going to belabor that. I suggest to you that, of course, you may not know this, but as of my last look, there's not a single appellate court case on this statute. It's first and only time it's ever been pulled out to be used somewhere. Okay? And I think it is constitutionally deficient because it doesn't even have a requirement of materiality. And we have materiality in every other similar type statute, perjury, false swearing, and so forth.
But isn't that argument a little late in the day? Shouldn't that have been done?
I'm sorry.
To dismiss?
Well,
Isn't that argument a little late in the day?
I think there was a motion filed on this before I was involved in the case, but I'm just raising the issue to you.
But
That's,
go ahead.
I'm raising that issue and saying that in addition to that, by way of argument, it's based on statements attributed to the defendant. And we filed pretrial motions to suppress, and hearings were held on various aspects of that. Was she in custody and entitled to Miranda, which was not done? Were statements obtained as a result of inappropriate agency in violation of various case law? We went through all that, and you ruled on that. But there's another aspect of it.
Okay.
There is a standard jury instruction that I reasonably anticipate that you will give, and I don't have it committed to memory. But it's essentially this: ladies and gentlemen, statements attributable to the defendant have been introduced as evidence in this case. If you find that those statements were involuntarily made by the defendant, you must disregard them. And I submit to you, I don't know where we're going to get, we hadn't got to that part of it yet, but I'm going to be requesting the rest of that statute, of that standard instruction, to include reference to the evidence. The witnesses in the form of Detective Yuri Melich, can't remember, none of the others came in here yet, are such that she clearly was never advised of her Miranda warning rights, despite having been surrounded by law enforcement officers on the 15th of July of 2008, put in the cage of Detective Acevedo's patrol car and driven around and questioned in various aspects, reiterating her positions that were contained in the motions to suppress. Coupled with that jury instruction, I suggest it may give you some food for thought. At least it's not quite as simple as it might appear as to those 4 misdemeanor counts of lying. The other cases that I've cited for you to read, Your Honor, you have there the Bough case, B-A-U-G-H, 961 Southern 2nd 198. In that particular case, there's various issues of lack of corroborating evidence, and reiterates the proposition that the state is required to prove every element beyond a reasonable doubt, and it cannot go to a jury unless they have done that. Not alarming law for you to have. Reynolds versus State is another important case, I think, that we rely on. R-E-Y-N-O-L-D-S, 934 Southern 2nd 1128. The issue in that was, again, considering whether there was wholly circumstantial evidence, and the standard, which I know that you are aware of the law, even though there was no evidence in that case directly. There were 2 women murdered without any indication of defensive wounds, and by the defendant, claim of whether he did it or did not. But there was no question as to the cause of death. These victims were bludgeoned to death with cinder blocks by their bodies and stabbed multiple times in the neck and torso with a knife and or with scissors. A violent struggle had gone on in this whole process. There were multiple stab wounds, a broken neck and a severance of the spinal cord as to one victim, Christina Razor. There were questions of fingerprint evidence and whether it was sufficient or not, of course, in the case. And if you read it and go through the facts and you think about the last 18 days of evidence we've had in this case, you got to say, yeah, well, where is any similar evidence in this case? And it reiterates in that particular case as well. Wholly circumstantial evidence and the special standard of review applies. And I think that you'll see that, wait a minute, there are some serious questions raised here because the state, despite the outcry, the notoriety, the emotions, so forth, the case is not here. I cited to the court the case of Cochran, C-O-C-H-R-A-N versus state, found at 547 Southern 2nd 928. Again, this is an evidence, a case where there was a confession, there were fingerprints that were important. The execution of the lady was a shot at close range. The body had been dragged out of the car, you'll find it particularly interesting. You make a note just for yourself to read page 2 of that, the site contained in that case historically. That case stands for the same type of proposition, Your Honor, that the circumstantial evidence and it has to so severely establish the no other explanation. In that particular case, the court's decision of a death penalty was reduced and because he overrode the death penalty. Ballard versus State, B-A-L-L-A-R-D, is another interesting case that discusses significant amounts of things. You might say, how about this case? They're talking about hair, talking a lot about hair evidence and whether it is or is not. They talk about the anagen phase, the catagen phase, the telogen phase, and all the things that we heard about in this case. And the Supreme Court in Ballard reversed a conviction and death penalty for acquittal. There was not just the hair evidence, there was a bloody circumstance and a crime scene that cried out for the fact that indeed there was a homicide. It wasn't just speculation as we have. Another case of importance to this court, I'm sure, is the case of Cox, C-O-X, versus the state of Florida. It's found at 555 Southern 2nd 352. It's a decision from 1989. Mr. Cox was convicted. He was sentenced to death by our recently departed mutual friend. And the Supreme Court reversed for acquittal. The state had relied totally on circumstantial evidence, and the Supreme Court in Cox said, insufficient. They had evidence of hair, blood, boot prints. Important part of the case is, though, recognizing that here again, a death sentence, not just commuted to life, but a reversal for acquittal. In Randall versus State, R-A-N-D-A-L-L, found at 760 Southern 2nd 892. The Supreme Court reversed yet another death penalty case, and this time vacating the death sentences and reversing it and saying that it can proceed on a second-degree murder because of the absence of evidence of premeditation. The court said in that case, some controlling language, in cases in which there is no underlying statutorily enumerated felony, premeditation is the essential element that distinguishes first-degree murder from second-degree murder. Where the state's proof fails to exclude a reasonable hypothesis that the homicide occurred other than by premeditated design, a verdict of first-degree murder cannot be sustained. And a reasonable hypothesis Of course, this case is accident. In fact, accidental drowning. The court discussed, in reference to this case and others, the absence of history. In the Serrano case, as I said a while ago, there was a history of bad blood, lawsuits, physical threats, physical confrontation, expulsions, lockout, execution, shootings, millions of dollars involved. Now, in this case, there is not any evidence of anything other than a caring and loving mother-child relationship. There is no confession. There is nothing but the circumstances that the state is trying to expand into some proof. As with yesterday, a piece of cardboard was found in the vicinity of the body, 9 or 10 feet away, as I recall the testimony of Dr. Michael Warren, anthropologist from the University of Florida. And that had a heart-shaped emblem stuck on that piece of cardboard. Nothing like anything related to this crime scene specifically. Remember, let us not get confused about what may be nothing more than media hype or whatever. The only evidence related to anything to do with a heart shape was the testimony of Ms. Fontaine, if I recall, from the FBI, saying she had observed an image of a partial similar heart shape on the edge of duct tape, but somehow, poof, they couldn't photograph it in the FBI crime lab at Quantico, Virginia. So we have no evidence then that connects that circumstance. The only evidence that we have about duct tape is it's severely questionable. Was it on the hair that when the decomposition occurred, and it would have been identified appropriately as slippage, but that the hair mat fell down and therefore positioned the tape near the mouth, in the vicinity of the mouth. And the only person shown to have had access to, use of, familiarity with the subject duct tape, unfortunately, was the grandfather. Testimony yesterday from the grandmother. Now, since I have a moment of your attention on this, I want to direct my thoughts to some of the case law that has been provided to me by the state of Florida.
One question before you proceed to that. You've mentioned accidental death, correct?
Yes, sir.
What record evidence is there of an accidental death that the court can look at that's in the record?
As of this point, there is no record evidence of accidental death. There is no exclusion, however, of the reasonable hypothesis of accidental death that was suggested and was the basis of some of your rulings, sidebar. And remember, the state has the burden, not the defense.
Okay.
State of Florida has cited a case of Law v. State, 559 Southern 2nd, 187, a 1989 Florida Supreme Court case. In that particular case, the facts and the establishment of the cause of death was not in dispute. The court found that each and every claim asserted by the defendant was contradicted by some testimony presented at trial, either by experts or other witnesses. The main variance in that case, and there can be, I suspect that if it were to be a contest of who can burn up the LexisNexis or Westlaw the most and find the plethora of cases and separate factual deals. In all of the cases relied upon by the state, there is no mystery as to the cause of death at all. They cite the case of Darling v. State, which has some interesting holdings in it that are referenced in the cases that I provided to you. Well, in this case, the victim had been shot in the head, sexually assaulted, fingerprint was connected to the defendant, DNA evidence related to the sexual assault was admitted. The court, in denying that the trial court had failed or had erred in not granting a judgment of acquittal, found that the defense apparently propounded of some consensual sex had not been established at all, and there was ample physical and forensic evidence of forcible sex. The cause of death, again, was clear, which is not only not clear in our case, it doesn't exist in our case. And they refer also to a Reynolds case 934 Southern 2nd 1128. That particular case, the defendant was convicted of 2 counts of capital murder, second-degree murder, and burglary of a dwelling. They determined that much of the evidence could not be deemed wholly circumstantial: confession to a cellmate, eyewitness testimony, prior history of dispute, DNA evidence, substantially different. And of course, the Serrano case I've already mentioned to you. The cases that Ms. Burdick provided this morning, I've not had a chance to digest, but I did scan them while we were waiting. And it appeared, again, that there, in each of those cases, was no question as to the cause of death. And therefore, the major concern of circumstantial evidence rule related to the principal issue could not really exist. In our case, there's no other way than circumstantial evidence. Circumstantial evidence, by the way, of what? How was this child killed? Where was this child killed? Was she killed at all? Or was it an accidental death? And I submit to you, Your Honor, I know you're burdened. I know the circumstances, as you well know, not my first time trying murder cases for 40 years. The fact of the matter is that there is no evidence of the main things that have to be. All the suspicion in the world, all the could haves, the probablys, the may haves, which was the quality of the testimony we heard from every single expert witness. Could have, may have, might have been. We have no evidence to exclude a reasonable hypothesis that there was no murder at all, that there was no premeditation, there's no history to suggest culpable negligence, there's no history in this case to establish any basis of aggravated abuse, and counts 1, 2, and 3 are not just ripe for, but screaming loudly and demanding judgments of acquittal in accordance with all of the authority that I presented to you and that the state of Florida has presented to you. Thank you very much.
Thank you, Mr. Mason. State.
Good morning, Your Honor. As the court so succinctly stated yesterday, the law is the law. And while a great portion of defense counsel's argument dealt with a recitation of what the law is, he spent the majority of it trying to distinguish specific facts of cases and comparing them to the unique facts and circumstances of this case. The cases that I had provided to the court the other day were not provided because they were factually similar, but because they quite clearly stated what I presume and believe the court and counsel already know, that at this stage of the proceedings, all inferences to be drawn from the evidence must be resolved in favor of the state of Florida. In fact, that the defendant admits all of the facts and inferences to be drawn from the evidence that has been presented. The reason Serrano, a recent opinion by the Florida Supreme Court, was included in the case packet was for the proposition under the law that the state is not required to rebut conclusively every possible variation of events which could be inferred from the evidence, but only to introduce competent evidence inconsistent with the defendant's theory of events. In Serrano, the defendant's theory of innocence was an alibi. The state, in that case, presented ample evidence to establish that Mr. Serrano's alibi was lacking. In this situation, the record evidence of a defense in the form of Ms. Anthony's statements to family, friends, and law enforcement was that an individual by the name of Zenaida Gonzalez kidnapped her child. And at that point, she had no contact with the child and obviously did not know what happened to the child. The evidence in this case has conclusively rebutted that hypothesis of innocence. Now, the suggestion in opening statement that there was some sort of accidental theory to be propounded at some juncture is exactly what I would argue Serrano is designed to avoid, that this is a possible variation of events that the state does not have to conclusively rebut. However, if the court accepts that the argument, or even perhaps some of the cross-examination of the witnesses, establishes that accident is a possibility, in this case, Dr. Garavaglia has stated unequivocally that this was not an accident. The suggested witness to this accident and its aftermath, Mr. George Anthony, has conclusively rebutted this hypothesis that at the judgment of acquittal stage, the defendant is proposing the court accept. I would ask the court to turn its attention to a case that I admittedly did provide this morning in some follow-up research that I had done yesterday. That's the case of Jackson versus State, found at 25 Southern 3rd, 518, an opinion of the Florida Supreme Court from 2010 out of Volusia County. In that case, it's on page 17 of the printout. I can't quickly tell you on what page of the opinion it is. I believe it's at 532. The defense challenged that the state did not present sufficient evidence that the victim died based on the criminal agency of another. In that circumstance, Dr. Beaver, who was the medical examiner in Volusia County in that judicial circuit, testified that because the body was badly decomposed, he was unable to perform a normal autopsy but examined remaining tissue and bones. He was unable to find a definitive injury to the victim and classified the victim's death as homicidal violence of undetermined etiology, which is almost identical to the verbiage used by Dr. Garavaglia in this case, homicide by undetermined means. There were a multitude of possibilities, hypotheses of innocence that were propounded in that circumstance by the defense, all of which were rebutted by Dr. Beaver, who, according to the opinion throughout his testimony, stressed that his opinion was based on his significant experience as a medical examiner, as well as the characteristics of the grave site, information he learned about the victim, and common sense. The opinion goes on to state that the credibility and weight to be given that testimony and that evidence were determinations for the jury. It is our position that a reasonable jury in this case can conclude that Caylee Marie Anthony died as a result of the application of 3 pieces of duct tape to her nose and mouth. That a reasonable jury can conclude that Caylee Marie Anthony died as a result of poisoning by chloroform. That a reasonable jury can conclude that Caylee Marie Anthony died as a result of the combination of the two, based on the evidence that was discovered in the trunk and the evidence connected with how her remains were discovered. It is our position that a reasonable jury can conclude that the relationship between the parties in this case, specifically Mrs. Anthony and her daughter Casey, could provide or did provide a motive for Casey Anthony to eliminate the child. It is our position that a reasonable jury can conclude that Ms. Anthony began preparations for the elimination of the child as early as March of 2008, when she conducted searches, computer searches, for how to make chloroform and other means of weapons and how to create injury. Jackson goes on to state that the state does not need to present evidence proving the exact manner of the victim's death or the location of the murder, citing Crane versus State, found at 894 Southern 2nd, page 54, Florida Supreme Court case from 2004, which affirmed a murder conviction based on circumstantial evidence, despite the fact the state did not establish how the murder occurred or even present the body of the victim. The only real issue as it relates to the judgment of acquittal at this stage has to do with the case of Brooks versus State. The defense presented only that case to the court, although it is apparent from the questioning that the court is familiar with the litigation that has ensued as a result of the Brooks opinion, which was issued in 2005 by the Florida Supreme Court. The first that I could find pronouncement as it related to Brooks actually came out of the 5th District Court of Appeals in 2006 in the case of Dorsey versus State, which is at 942 Southern 2nd, 983. In that case, Dorsey does not address whether or not the language regarding the merger doctrine between aggravated child abuse and first-degree murder would require a judgment of acquittal on the felony murder theory. In Dorsey, the Fifth District Court of Appeals questioned whether or not shaking, in that circumstance, shaking a child to death could ever be considered a single instantaneous act. The act, of course, in Brooks that was under consideration was the stabbing, a single stab wound to an infant. And the Fifth District Court of Appeals distinguished Brooks on the basis that the mechanism required or that did result in the death of the child in Dorsey was something that was more than a single instantaneous act. The court had mentioned Amanda Lewis, which came out of the First District Court of Appeals in May of 2010. In that case, Ms. Lewis was convicted of drowning her daughter by holding her under the water in a swimming pool. And again, this is where the First District Court of Appeals has indicated that the language in Brooks was dicta, not essential to the conclusion, and therefore they weren't going to apply it, and also questioned whether the act of holding the child under the water was a single act of aggravated child abuse. What's interesting is that subsequent to Lewis in Sturtevant, which is, I only have the Florida Law Weekly site, 35 Florida Law Weekly, D 1993, a decision of the First District Court of Appeals in September of 2010, conflicts. The panels in the First District Court of Appeal conflict with each other as to whether or not the language in Brooks is in fact dicta. Appended to the opinions in both Lewis and Sturtevant, I attached the minutes as of last evening, released the docket minutes from the Florida Supreme Court as to the status of both of those appeals. Lewis is on hold pending resolution of the matter in Sturtevant. The last entry in the docket has to do with the reply brief, which is dated 2/1 of 2011. The other opinions dealing with this subject, again, coming out of the First District, is Lim versus State, LIM, found at 50 Southern 3rd, 34, which is a First District Court of Appeals case from December of 2010, where regardless of the language in Brooks, they indicate that the multiple events surrounding the victim's death would take it out of the holding in Brooks. Similarly, the Second District Court of Appeal in Rosa versus State, which was a case out of Hillsborough County, the opinion is dated March 2nd, 2011, cited at 58 Southern 3rd, 900, that more than one hold or grip on the victim during a single act of abuse or of strangulation, the holds during the strangulation did not constitute a single act of abuse. Therefore, it is our argument to this court that since a reasonable jury can conclude that Caylee Marie Anthony's death was caused by the application of multiple pieces of duct tape, which obstructed her airway, both her mouth and her nose, based on the evidence presented in this case, that would not constitute a single act of abuse under the theories espoused by the various district courts of appeal in this state, and therefore the aggravated child abuse does not merge into the homicide and preclude us from the application of the felony murder rule, either as it relates to the application of the duct tape or the administration of a poison to the child for whatever purpose. The other issue for the court's consideration as it relates to the judgment of acquittal has to do with the issue, admittedly, of premeditation. I've touched upon this very briefly, and I will not belabor the point, but at this juncture, resolving all inferences in favor of the state, the question is whether or not there is substantial competent evidence from which a jury could conclude that Ms. Anthony, based on her computer searches, based on the manner in which the evidence establishes that the child died, whether that can be concluded conclusively by the medical examiner, that this was an intentional act by the defendant designed to cause the child's death. That there is no fixed period of time that must pass, despite earlier evidence of computer searches. But that when Ms. Anthony decided to place duct tape on the child's face, not one application, not two, but three, that sufficient time had passed for her to understand the nature and quality of that act, and that premeditation has been established as a result. Therefore, we would ask the court to deny the motion for judgment of acquittal as it relates to all counts of the indictment.
You may.
And I thank the state for pointing out some of the depth of the errors. Let's start. If I heard correctly, the state is suggesting that they have presented evidence to overcome the motions here by talking about poisoning by chloroform. Now, I realize my hearing disabilities are such, but I don't believe there was any evidence whatsoever of poisoning by chloroform. In fact, Dr. Garavaglia acknowledged, if I recall, that the issue of chloroform had to do with the claim that there had been detectable chloroform traces from decomposition, and that she, in fact, employed the services of Dr. Bruce Goldberg from Gainesville, a toxicologist PhD, who said that every test they knew how to do scientifically was done to try to fit that square peg in a round hole, and they couldn't do it because there was no chloroform related to the death of this child at all. The duct tape issue, we established that despite suspicions and arguments, the duct tape had not been wound around this child's head at all. And all prior reports and suspicions of that were bogus. There were 2 pieces of duct tape found, one attached to some hair, the other one attached to it, and a third piece 9 or 10 feet away. It is a stacking impermissibly of inferences and suspicion on suspicion to suggest, first of all, that it had anything to do with the cause of death. And as important, that anything had to do with Caylee Marie Anthony. There is no evidence of that. You can't even guess that far. There's no fingerprints, there's no admission, there's no witness, there's no possession, there's no utilization. The only use of duct tape evidence in this case was George Anthony putting some over a breather valve on a gas can, which sits right there in evidence, and that there was similar duct tape on a command center flyer looking for a missing child. The only person having that was not this defendant. She mentions computer searches. Well, the only evidence computer searches seem to have been on unrelated issues of self-defense and prior to any relevant times. You can consider that yourself. More importantly, though, I want to talk to you just a little bit about some case law handed up this morning. And, you know, with the advantages of another volunteer, my colleague Elizabeth Fryer, reading these while we were talking and giving me notes. And then I was able to grab this Jackson case. What a world of difference. In that case, the medical examiner did not say that his opinion was based on a preponderance of the evidence, an improper standard, like Dr. Garavaglia did. Further, the evidence was that was a drug deal, a kidnapping, prior threats, and a shooting. That has nothing to do with our case. And reading the notes as to each one of the cases they cited, if the court will please do that when you review this. Abdul versus State case cited by the state at 53 Southern 3rd 208. 3 witnesses testified that the defendant spoke of and planning to kill the victim on the night of the crime and went and got, interestingly enough, duct tape, a gas can, and gasoline, which were used to kill the victim. Doused with gasoline and lit on fire. Norton versus State, they cited 709 Southern 2nd 87. Gunshot wound to the back of the victim's head. And by the way, that wasn't sufficient to establish premeditated murder. But it goes to the point is how distinctive are these authorities from the weakness of the evidence that we have in this case. If you look at these cases, I've gone through every one of them as briefly as I can here. We then go to this concern about this merger doctrine. I know what Lewis says. Somehow, without evidence, without basis, there's a suggestion that in that case, the drowning by holding the victim under the water was more than one act. That's speculation. There's no evidence of that in that case. How in the world? I mean, I know that bad cases don't make good law and all that routine, but don't tell me that there's evidence that that mother in that case was repeatedly dunking this child. There's no evidence that somebody made a conclusion. In our case, there has been no evidence presented that Caylee Marie Anthony used duct tape for any purpose, that she used chloroform ever for any purpose, and that in any way or any capacity whatsoever, she contributed to the cause of death of this child. It is forcing, guessing, and speculation, and not in this country. I ask the court to please take the time to read all these authorities before you rule. Theirs and ours. Thank you.
Okay, the court will be in recess until 11:15. Just a second. To let both sides know, I have read most of these cases, and I have spent a great deal of time over the weekend researching and reading all the cases, and on last evening I have reviewed the testimony that has been given in this case. So we'll be in recess until 11:15. Let the record reflect that the defendant is present along with counsel for the defendant. Both the state and the defense have presented their arguments on the issue of the motion for judgment of acquittal. Both the state and the defense cited the case of Serrano versus State, a March 17, 2011 decision of the Florida Supreme Court, which correctly lays out the standard for motions for judgment of acquittal. There's another case that the court also took in consideration, the case of Durisso versus State, found that 55-7 3rd edition 543, a December 9, 2010 opinion of the Florida Supreme Court. The court in that opinion goes on to say that when faced with a motion for judgment of acquittal in a circumstantial evidence case, the trial court must determine whether there is a prima facie inconsistency between the evidence viewed in the light most favorable to the state and the defense theories, citing Reynolds versus State, 934, 7 2nd, 1128, a 2006 decision of the Florida Supreme Court. The court in that opinion goes on to say, under the circumstantial evidence standard, where there is inconsistency between the defendant's theory of innocence and the evidence, when viewed in the light most favorable to the state, the question is one for the finder of fact to resolve, and the motion for judgment of acquittal must be denied, citing Floyd versus State, 850, 7 2nd, 383, a 2002 decision of the Florida Supreme Court. The court goes on to say, we have held the state is not required to rebut conclusively every possible variation of events which could be inferred from the evidence, but only to introduce competent evidence which is inconsistent with the defendant's theory of events. If the state has presented evidence to support every element of the crime, then a motion for judgment of acquittal must be denied and the denial affirmed on appeal. Once that threshold burden is met, it becomes the jury's duty to determine whether the evidence is sufficient to exclude every reasonable hypothesis of innocence beyond a reasonable doubt. Whether a premeditated design to kill was formed prior to a killing is a question of fact for the jury to be established by circumstantial evidence. Pierce versus State, 880, 7 2nd, 563, a 2004 decision of the Florida Supreme Court. Evidence from which premeditation may be inferred include such matters as the nature of the weapon used, the manner in which the homicide was committed, citing Griggs versus State, 753, 7 2nd, 1117, a 1999 decision of the 4th District Court of Appeals. Where the elements of premeditation is sought to be established by circumstantial evidence, the evidence must be inconsistent with every other reasonable inferences. Those are the principles of law which this court must abide by. The Florida Supreme Court in the case of Rose versus State, which is cited at 425 7 2nd, 521, a 1982 decision of the Florida Supreme Court dealing with a case involving circumstantial evidence. The succinct facts of this case was that the defendant was the last person seen with the victim. In that particular case, the defendant did have some motive. What basically happened in that case was there was an 8-year-old victim by the name of Lisa Berry. The evidence revealed that the defendant was the last person to be seen with young Lisa Berry at a bowling alley. The evidence showed that he left with that particular young victim, and that he had dated the mother for about 9 months. They were no longer dating because of he was an extremely jealous person. Subsequent to this, he was found with a large spot of blood on his pants, the same blood type as the victim. There was fiber evidence, and the defendant made numerous statements that were inconsistent. The court concluded that that evidence was sufficient to sustain the crime charged in that particular case, first-degree murder and kidnapping. The next case the court reviewed and had reviewed prior to the state citing this case was Cranen versus State, 894, 7nd, 59. In this particular case, there are some interesting facts. In this particular case, the evidence showed that the defendant, who was 52 years of age, met the victim's mother, that he was the last person seen with this particular victim. It is interesting to note that the last time that the child was seen, she was seen sleeping next to the defendant in this particular case, and then the person abruptly disappeared. The Supreme Court, in finding that this evidence was sufficient, cited a case out of the Supreme Court of Virginia, Epperly. That case is found at 294 Southeast 2nd, 882, a 1982 decision of the Supreme Court of Virginia. In that particular case, the victim in this particular case disappeared on a night in June of 1980. She was last seen leaving the Marriott Hotel in Blacksburg. She left with the defendant in this particular case, went to a lake house, and ultimately disappeared, her body never being found. And the court goes through a long dissertation in that particular case and talks about premeditation and what premeditation meant. There is another case of interest for persuasive value, which is found at 323 Northeast 2nd, 888, a Supreme Judicial Court of Massachusetts decision in 1974, which is still good law in the state of Massachusetts, for persuasive value. even though it is not binding on this particular court. The evidence presented in this particular case was that on February 16, 1973, sometime after 4 p.m. on the first floor of this particular building, a tenant heard moaning sounds coming from the direction of a cellar. This particular witness, along with her husband, took a flashlight and went to a cellar where they observed a boy lying naked face down on the floor. They immediately got law enforcement assistance. The police arrived, and they took the boy to the hospital for treatment. He remained at the hospital for a few days, was later discharged, came back home. His condition began to deteriorate, and he was taken back to the hospital where he remained until his death. The evidence in this particular case was that the victim was last seen in the company of the defendant prior to the disappearance of the victim. The defendant and the victim were seen together shortly before the victim's disappearance at the front entrance to this particular building. He was seen by two separate individuals. One independent witness and a detective who happened to be in that particular area making surveillance of the area, observed the defendant and the victim on the front porch of the residence in question, walking into the doorway at approximately 3:45 p.m. The victim was discovered shortly after 4 p.m. on that particular date. Again, this court was faced with a question of whether or not this was sufficient evidence. The court concluded that this was sufficient evidence since the defendant was with the victim immediately prior to the victim having been found strangled and naked. They had been seen together entering the building in which the victim was found. It could be inferred from the layout of the cellar and the generally the problem of anyone being able to gain entrance thereof, that was basically the only way that they could enter or leave that particular building. And the court goes on to lay out other particular reasons. The last case the court reviewed was a case out of the Supreme Court of the state of Arkansas, Zone versus State, found at 702 Southwest 2nd 1, 1985 decision of the Supreme Court of Arkansas. Again, in this particular case, the appellate and his co-defendant were the last two individuals that were seen alive with this individual. The appellate tried to make the argument that his co-defendant was the one who did it, made certain statements. The court concluded that this was sufficient evidence. The defense brings up the issue in talking about whether or not felony murder would be applicable, the Brooks case. And the court has reviewed Brooks, and the court has reviewed Amanda E. Lewis versus State, a 2010 decision of the First District Court of Appeals found at 34 Southern 3rd Edition 183 on the doctrine of merger. The First District points out a couple of things. One, the felony murder statute specifically provides that aggravated child abuse is a predicate offense for felony murder. The plain, unambiguous language of the statute demonstrates that the legislature intended that a defendant who kills a child during the perpetration of the crime of aggravated child abuse may be charged and convicted of both aggravated child abuse and felony murder, regardless of the number of acts of abuse which caused the child's death. And they go on to talk about Justice Lewis's dissent in Brooks, disagreeing with that particular analysis by the Supreme Court. As Mr. Mason, though, pointed out, that law is the law unless the Supreme Court decides to change it. The key argument is whether or not there is more than one single act that leads to the abuse or death. In this particular case, there is more than a single act. Those acts consist of duct taping the nose, mouth, the presence of chloroform in the trunk, coupled with the fact that there is evidence that the child was placed in a trash bag and other container, and the statements introduced into evidence that even during this time period, Ms. Anthony, through statements that she made, that the child was alive during various segments of this time. So it is quite clear in this particular case that there is more than one single act which satisfies the test of Brooks versus State. Considering the evidence in the light most favorable to the state, and reviewing all of the evidence and considering the tests that have been laid down by the Florida Supreme Court, the defense's motion for judgment of acquittal as to counts 1 through 7 are hereby denied. These are strictly questions for the jury to decide. The court specifically finds that the state has presented substantial, competent evidence for this jury, who is the trier of fact in this particular case, to decide this particular issue. This court will be in recess until 9 a.m. tomorrow morning.